Mr Acting Deputy President, I too can indicate my support for the second reading stages of this bill and for the bill generally, but I do have a number of reservations, and fortunately we will be having, I hope, will be a constructive second committee stage of this bill in order to discuss those concerns and in order to consider appropriately amendments that have been put up. Mr Acting Deputy President, there is no question that one of the key roles of the state is to protect the public from terrorist acts. That is axiomatic. Public safety is a paramount consideration. But if you accept the necessity of intelligence agencies, and I do, I think it's a no-brainer, then you have to accept the necessity for those intelligence agencies to operate in secret and to have adequate powers and resources to do their job. If you don't accept that they must operate in secret, then you're not being serious about protecting the public. If ASIO exists, for example, it needs a high degree of operational secrecy. It needs to assure all its current and future sources and all current and future partners here and abroad that it will keep their secrets. Failure to do so in one case affects its credibility in all cases. Thus, any compromise of ASIO's credibility when it comes to protecting its secrets in one area could affect its credibility in relation to sources and methods in all areas. Similarly, if we are to have an effective ASIS, then it too needs a high degree of operational secrecy. To deny its operational secrecy is to deny its ability to exist. However, national security is and must be a key goal and one of the key roles of the state to protect its citizens from harm, from terrorist attacks. It must never be an alibi for abuses of power. I have grave misgivings, therefore, about some provisions in this bill that impose harsh penalties for disclosure of intelligence information with no consideration given to a public interest exemption. Let me give two examples that are not hypothetical. The first relates to so-called Witness K. I refer to reports that the Australian government had breached international law by ordering the Australian Secret Intelligence Service, ASIS, to bug East Timor's cabinet rooms during the 2004 bilateral negotiations over the Timor Sea Treaty relating to oil and gas. This cannot possibly have anything to do with national security. East Timor is no threat to Australia. At the time of the special operation carried out by ASIS, East Timor was the poorest country in Asia, and during the Indonesian occupation it had suffered the largest loss of life relative to total population since the Holocaust. A key whistleblower here is a former Australian spy who is said to be the Director of all technical operations for the Australian Secret Intelligence Service, which allegedly conducted the bugging operation using the Australian aid program as a cover. This aspect of the allegations is extremely disturbing. If the espionage operation used the Australian aid program as a cover, then it has endangered the safety of Australians who are good, well-intentioned people who go overseas to many parts of the globe in order to work with those who are less fortunate. As the Age editorial of the 11th December 2013 stated, deceit of this kind brings suspicion to all non-government aid workers, irrespective of who they are and what they do. It runs the risk of endangering all legitimate aid workers who seek to help the disadvantaged. Aid agencies operate in extreme and difficult conditions, often on the front line of danger and often in countries where they are constantly at risk from brutal regimes. They dare to help when no one else will. To deploy intelligence agents under the cover of aid workers is to exploit the fragile trust that aid agencies must forge with their host country. It weakens their security because it discredits altruism. That was the Age editorial back in 2013. We should be grateful that the ex-ASIS whistleblower, and to others like him, the whistleblower known in the press as Witness K, has not endangered Australia's national security. Instead, he has shone a light on a most disreputable episode in Australia's foreign policy. It is unjust to pass a law that would send someone like him to prison for up to 10 years. It is unjust to pass a law that would deprive someone like him of his freedom for a substantial period of his life without any consideration of his motivations, nor indeed of the public interest considerations in respect of that. Whistleblowers like him do not appear to be motivated by money or career prospects. Rather, they appear to be moved by a sense of duty to answer the call of basic human morality. This bill makes no distinction between people like him and people who do us harm. And let me put this in perspective so that the attorney does not misunderstand where I'm coming from on this. If there is a special intelligence operation, and as a consequence of that special intelligence operation, that there are people working undercover with a terrorist cell, if the identity of that person is disclosed, that is a very serious matter, and I support the government in treating it as a very serious matter, because you could effectively be passing a death sentence on that person by disclosing their identity, an undercover operative who's working in that sort of very sensitive operation. So I get where the government is coming from, and I commend them for acknowledging, for wanting to strengthen the legislation where the lives of intelligence operatives and our sources are put at risk. But in the case of Witness K, that is a clear distinction. That is something that I think is very, very different from the circumstances which I have just set out. And in those circumstances where I believe it was in the public interest to know about that operation, a matter where international law, I believe, was breached in respect of that, then that person, Witness K, cannot be treated in the same light as someone who is endangering the lives of security operatives who are working to protect Australia's interests. There's also the case of Dr Hanif. My colleagues will also be familiar with the case of Dr Mohammed Hanif, an Indian national who was arrested at Brisbane Airport on the 2nd of July 2007 in connection with a failed London bomb plot. Actually, it was in Glasgow, I correct that. Dr Hanif was held for 12 days before being charged with providing support to a terrorist organisation. This is an offence for which he could have been jailed for up to 15 years. The charge was unsustainable and was quickly dropped. Meanwhile, his immigration visa was cancelled on character grounds. This was later found to be unlawful. The Honourable John Clark QC conducted an inquiry into the Hanif case. He concluded that Hanif was wrongly charged because an individual AFP officer, Commander Ramzi Jabbour, had, quote, lost objectivity and was unable to see that the evidence he regarded as highly incriminating in fact amounted to very little. No disciplinary action was recommended to Commander Jabbour, and I want to emphasise, Mr Acting Deputy President, here that the inquiry found that Commander Ramzi Jabbour was, quote, impressive, dedicated and capable, yet he was acting selectively, even cynically. He was keeping evidence that might exonerate Dr Hanif from the magistrate who was detaining the doctor in the Brisbane lockup, and also keeping evidence from Immigration Minister Kevin Andrews, who cancelled his visa. This is where this bill is weak. It assumes a best-case scenario at all times, and the impeccable behaviour by all concerned. Yet Commander Jabbour was not a bad person. Indeed, the inquiry found that he was presented as a committed, professional and competent individual and was held in high esteem by the officers he led. If this operation or something like it had been a special intelligence operation, and this, in the Hanif case, it was an overt, not a covert operation, but it could have just as easily have been a covert operation, the details could not have been reported unless the reporter was willing to risk up to 10 years in prison. It should not be left to prosecutorial discretion whether a reporter would be tried in such a case. There must be a public interest exemption, or at the very least, and I'm moving an amendment to this effect, that public interest matters must be considered in the course of fixing a penalty. Now, on the issue of disruption of target computers and third-party computers, and I am grateful to the Attorney's Office for the communications I've had with them, and I'll refer to the response I received just a few minutes ago. But I do want to set out the concerns that have been expressed to me by people that work in the field of cybersecurity. The bill allows the targeting of third-party computers. In other words, it allows ASIO to break into computers belonging to innocent people in order to obtain covert access to a target. What happens when ASIO accesses the servers of an internet services provider to read the emails of a target? If ASIO has obtained the cooperation of the company, or if the systems administrator, by virtue of the ASIO affiliate scheme, then they will be able to do what they need to do with no disruption to the network. So far, so good. But what happens if ASIO decides to breach a system without the consent of the company? If the company spots the intrusion and tells all its clients that it has been attacked, would that be disclosing information about a special intelligence operation? Now, the Attorney's Office has indicated to me in an email, and I'm grateful for that, that would not be the case, but it would be useful in the context of the committee stages simply to confirm that, because that has been a real concern that's been expressed to me. Another problem that I can foresee is that an attempt to enter a network undetected is usually accompanied by privilege elevation, seeking to elevate low privilege users to super user. This is because user accounts can only read, write their own data and run some applications, but systems accounts can read, write any data and run all applications. Successful privilege elevation would allow ASIO continued access via so-called rootkits or so-called backdoors. A backdoor is a method of bypassing normal system authentication accomplished by installing software on the host, using remote access administrative tools and exploiting vulnerabilities in the target system, in other words, such as default administration accounts. While a symmetric backdoor can be used by anyone, an asymmetric backdoor can only be used by the attacker. A rootkit is a stealthy backdoor which provides persistent privileged access to a system. It is usually installed after the attacker has gained system-level access. It can alter system logs and registry values. What happens if another outfit, an individual hacker or group of hackers or foreign government signals intelligence directorate, detects the rootkit and also gains access after ASIO has done its job? Won't the target be permanently weakened? So the question I pose, and I pose it genuinely and sincerely, is there what safeguards are there so that we won't make systems more vulnerable as a result of an intelligence operation to those that have evil intent towards Australians? On the issue of oversight, as the Right Honourable David Davis, a leading figure on the backbenches of the UK Conservative Party and editor of The Future of Conservatism, Values Revisited, has argued, and I quote, "Security services handpick recruits who are intelligent, tricky, quick-thinking and determined, the sort of people who will pull out all the stops to protect the public. This is exactly what our spies should do. However," he says, "it is inevitable that any big bureaucracy, government departments or agencies will at some point misuse the powers it has and the data it holds. If we can't trust government departments, the Met or even our health service to respect our privacy and personal information, we should not trust the security services either. As David Davis points out, we, quote, "we cannot expect James Bond to behave like Mother Teresa." That is why there must be clear limits on the spy's powers. I would like the Senate to call on the government to investigate the establishment of a committee independent from the executive arm of government to oversee Australia's intelligence services, and similar in operation to the FISA, the Foreign Intelligence Surveillance Act Court in the United States, and the Parliamentary Control Panel, the G10 Commission and the Confidential Committee in Germany. I so move my second reading amendment to that effect, Mr Acting Deputy President. There is clear judicial oversight in the United States. The FISA Court, consisting of 11 federal judges who are appointed by the Chief Justice of the United States, meets in secret, allows only the government to appear before it, and provides an annual report to Congress concerning its activities. There is also clear legislative oversight in the United States. The intelligence committees and judiciary committees in the Senate and the House of Representatives exercise general oversight over all intelligence collection programs, and committee members are regularly briefed. Members of Congress will receive detailed briefings prior to each reauthorisation. And I note that the Attorney's counterpart in the United States, Eric Holder, has done some interesting work in terms of metadata and protocols in place with the media, so that the media does have protocols and safeguards in place so that there isn't needless metadata searches of journalists, for instance, when contacting their sources. And I think that is something that is important, and we need to look at that and look at emulating it. There is also excellent oversight in Germany. The Parliamentary Control Commission exercises legislative oversight over the intelligence agencies. The Chancellery is obliged to inform this committee at least once every 6 months about the activities of the intelligence services. The Commission can request documents and data and conduct hearings with members of the intelligence services. The Parliamentary Control Committee's deliberations are kept secret. The Parliamentary Control Committee also appoints the 4 standing and the 4 deputy commissioners of the G10 Commission, which serves as a permanent control body for intelligence activities. The Commission reviews and authorises all requests for surveillance activities subject to the G10 law. The Chair of the G10 Commission needs to have the qualifications to serve as a judge. It meets at least once a month and can schedule on-site control visits at German intelligence facilities. The G10 Commission does not only authorise surveillance programs but also controls how these programs are implemented regarding the collection, storage and analysis of personal data. The intelligence agencies have to justify their surveillance requests and specify their scope and targets. The German oversight mechanism belongs to the legislative branch and does not include judicial review. And I can indicate parenthetically, Mr Acting Deputy President, that the reason why they have those safeguards in Germany arises as a result of the excesses of the Stasi with communist East Germany about their enormous surveillance of citizens, and it is a response, in a sense, when Germany was reunified to deal with those excesses and have those safeguards, so the awful excesses of the Stasi could never ever be repeated in Germany. By comparison, Australia currently has the weakest oversight mechanisms, and this is not a criticism of this government. This is something that has occurred over, it's a cultural issue almost, over a number of years. It lacks institutionalised review of surveillance programs from both the legislative and judicial branches of government, despite claims that Australia's courts may be unable to evaluate intelligence expertly. Courts routinely evaluate complex evidence in other areas, from complex corporate transactions to elaborate taxation schemes to highly structured trust arrangements. Courts do not typically object that they lack the expertise in the complex areas of commercial litigation, taxation or mergers and acquisition deals. I believe that our courts have the capacity, our judicial officers have the capacity to provide the sort of oversight that they have in the United States and in Germany and indeed in the United Kingdom. Finally, Mr Acting Deputy President, I want to make reference to the comments made by Brett Walker SC on the national security amendments on the ABC's Late Line program last night, in an interview with Steve Kinane, the presenter of the program. I will refer to this more in the committee stages of this bill, but I think it is fair to say that Mr Walker had some views as the former the first independent national security legislation monitor, someone who's highly respected in the legal profession nationally in this country. But there are concerns. There are concerns in terms of what the implications will be for releasing information. The instances I've given of, say, witness K, the instances of, say, the Hanif case, where clearly there were some issues in respect of that case that were unsatisfactory, and if it was a covert operation, it would have led to significant penalties for anyone reporting on that. And he does distinguish, Mr Walker SC does distinguish between someone deliberately sabotaging special intelligence operation and, of course, I acknowledge the risk that poses to the men and women of our security services and their associates whose lives would be at risk if that information is disclosed, and that is why we need to have appropriate and significant penalties. But it was put to Mr Walker, if, for example, politically embarrassing leaks from the intelligence service didn't endanger lives, whether that would be, whether the same sort of penalties ought to be put in place. And I think that what Mr Walker said, his caution in respect of that, ought to be heeded. I am concerned that there is no distinction made between someone who is clearly acting in the public interest, where there is no question of an intelligence services, an intelligence officer's life being at risk, or indeed the operation being at risk, such as the Witness K example with respect to East Timor. So these are matters that need to be explored in the context of the committee stages. I have provided the Attorney's Office details in advance of some of my concerns, because I do want there to be a constructive discussion in relation to this. I genuinely want to engage with the government in respect of this, but I have concerns that some parts of the legislation have gone too far without adequate safeguards, and I think that is why this committee stage of this particular bill is particularly important.
Thank you, Senator.